So what was I going to say? Look, I think even Robin would agree that stop, question, and frisk, if properly used, is an essential police tool. I mean, you know, police get a call of a man with a gun and a clear description, and they show up, and there's a guy exactly matching the description. There's a bulge in his pocket. The cop doesn't have to just walk away. Okay, so so the question is, how then do we exert control and enforce responsibility over stop, question, and frisk? To my mind, that letter from the police commissioner, which was very recent, gives me hope.
You know, I can't wait to see a new world. And I'm glad that you're optimistic and maybe you have some inside information that I don't have. And you will forgive me if I'm slightly skeptical that the police commissioner is responding after probably a decade of information, criticism, and New York Times editorials, lawsuits, social justice organizations raising this issue over and over again, and people raising it in the criminal justice system, and that it is just shifting right at the moment that he might want to run for the mayor. Just saying. So, you know, I'm a little skeptical. I'm a public defender. That's how we're born. We are born to be skeptical of authority, and that's sort of the view that I have of it. But, you know, it would be lovely if all those things were to change. I mean, there's some problems, and obviously, look, the description of the form that you have pointed out is clearly what the problem is, right? Some of the problem with the way policing is that even if you're filling out a form about the reason you stopped and frisked, and you have descriptions like furtive gesture, right? In the dark of the night, on the stairway stoop, if you're a black man standing in front of your building and the police stop you and you reach into your pocket to get your identification or your keys, you may very well be shot dead on the street in the South Bronx. If you are standing in front of your brownstone on Park Avenue and you are white and you're well-dressed and you're carrying a briefcase and the police stop you and you reach into your pocket, they're going to assume that you're actually reaching for your keys. So the idea of what furtive gesture means is riddled with its own sort of ability for there to be racial bias and there to be class bias about who the police are, who are policing what communities, and how they see members of that community. So even if we have those things, I'm not saying it's not a good thing, it's better than having nothing. But understand that a furtive gesture in one neighborhood looks differently than a furtive gesture in another neighborhood if you're a cop not from that neighborhood. Right?
I think we got some questions.
I was going to say, we're going to have questions at the end, but you know what? I think we're having a good conversation.
Good.
Yes.
Can you speak a little bit about the Bronx Freedom Fund and why it didn't receive more support?
Ah, what a great question. Thank you for that. So the Bronx Freedom Fund was something that the Bronx...
She's like Mitt Romney. She brings
It's awesome. I am so not like Mitt Romney. Wow. So what the Bronx Freedom Fund was the Bronx Defenders, our response to what we saw as bail being used in New York City to basically keep poor people in jail who couldn't fight their cases from the outside, right? So bail would be set at $250 or $500 or $1,000, and people would sit at Rikers Island because their families couldn't get enough money together to post bail in the Bronx, which is the poorest borough in New York City and one of the poorest congressional districts in the nation. People didn't have the money to bail out, and when you don't have the money to bail out, what do? You plead guilty to get out. So if you're in on a marijuana case with a bad stop, or you're in on a trespass case, or even a robbery where you were not the person who did it, or even the person who did it but they can't prove it, it's really hard to fight your case if you're sitting at Rikers Island and they offer you, if you plead guilty tomorrow, we'll let you go home. If you don't, you're going to wait for a trial, which will probably take 3 months, 6 months, 9 months, a year. In the Bronx, it'll take a year or two to get to trial. So people pled guilty, and it was sort of an example of the ways in which affluence can really impact the results of a case, right? And how justice shouldn't be determined by the size of your wallet, right? So we set up this thing called the Freedom Fund, created a separate 501c3 with its own board and its own rules of operating. We got a very large donation from the Joe Flom Foundation and began to actually post bail for people charged with misdemeanors and nonviolent felonies, where the bail was under a certain amount and where people had established ties in the community so they could fight their cases from the outside. The bail fund ran for about a year and a half, and some of the results of that were fantastic. We kept careful data, right? And one of the things we saw was more than half the cases were dismissed outright by the prosecutors by the time they actually went to trial, because people were out and they weren't pleading guilty. What we saw was that even people that pled guilty, nobody got a jail sentence. And so you kind of begin to recognize the impact that staying in jail and bail has on pushing people and forcing people and pressuring people to plead guilty to jail sentences and to things that they may not even have done or the prosecutor can't prove. So we had this great data going, and then we ran in front of a judge whose name is Ralph Fabrizio. And I name names, by the way. And Ralph Fabrizio decided, he's a judge in the Bronx, and he decided that he wanted to get to the bottom of what this bail fund was about, and he was mad. Now, why did he get mad? He got mad because we made a bail application on behalf of a young man who was in jail and tried to get him out. He denied the bail application, wouldn't let him out, held him in on bail, and then saw him a couple hours later walk out from the back of the courtroom to freedom in the hall. Turned to the court officer and said, how did he get out? The court officer erroneously then said, oh, the Bronx defenders bailed him out, as if the defense lawyers had done it, instead of the Bronx Freedom Fund had bailed him out. Judge Fabrizio went more than slightly crazy and called me over and called all sorts of people over, and it ultimately wound up in a hearing. And the hearing went on for a very long time, and ultimately, he decided to revoke bail on that client's case, but then release him anyhow because the young man had made 18 court appearances and never missed one. So he didn't actually go into jail. But what it exposed for us was that the insurance board in New York forbids you from posting bail without being registered with the insurance board if you're doing it more than 2 times a month. But the idea behind that law was that it was to actually cover bail bondsmen. And nobody had ever questioned about whether the law applied to a not-for-profit before. So we conferred with some of the biggest law firms in New York City, and they disagreed about whether or not we would be covered by the insurance board law or not, and whether it was operating, safely or not. And in an abundance of caution, since they disagreed, 2 big law firms disagreed, we shut it down until such time as we can actually get legislative amendment to the law, which is what we're working on now. You should know, so if you're voting in New York, you should know that the bail bond statute that we helped write and was passed in the Senate and the Assembly unanimously in both places. And Gustavo Rivera, our senator, who really helped us get that it passed unanimously. And on the very last day, Governor Cuomo vetoed it at 5 minutes before midnight. And so we're now back at the drawing board trying to rewrite it. So that's why it's actually not operating right now, but that was its purpose. Its purpose was to provide literally funds for families who can't bail people out so they can fight their cases.
Let me say it in part because Judge Fabrizio is a former colleague of mine and a friend. You may want to actually look at the...
Sorry.
You may want to look at the... he wrote a very long opinion on that. And also I'll say this, that about 20 years ago, someone named Judy Green, who at the time was working for the Vera Institute, a nonprofit in New York, actually got herself licensed as a bail bondsman to work a project very similar to this.
Yeah, but you need over $1 million collateral to do that.
Look, and here's what I want to say. This is where my sister Robin and I are completely in agreement. I don't think any fair-minded person could look at the bail system from either side, from any side, the way it exists today and think that it makes sense. I mean, it drives us prosecutors crazy too, for many reasons. One of them being, the statute says you're not supposed to be able to put up as collateral for a bail bond money that is the fruit of a crime. Well, I can assure you, when a bail is set on a drug dealer of $250,000, they find some really clever ways of finding people to put up the bail money that do not pass the red face test. I'll never forget the first time. It's called a surety examination. We have the opportunity to examine the surety. And, it's the niece of the husband of the cleaning lady of my best friend is putting up $50,000 that she keeps in the house. Huge sums of money that really have no way of tracing. And I think it breeds cynicism in the system from our side too. So, look, Robin's right. What's the purpose of bail? The purpose of bail, says the law in New York, has only one purpose, unlike federal law. The purpose is to make sure the defendant shows up for court. And if some nonprofit can guarantee that that defendant will show up for court, then the purposes of the bail system have been satisfied. I'll tell you though, what sort of kind of sharpened my view of that as well was when I was a young assistant working with my colleague John Quinn in part AP3, the lower court. And at 2 o'clock every day, they would call the warrants. Yeah, said, what do they do? There's like a high school graduation. They read like 30 or 40 names. Oh, who are they? Well, those are the people who didn't show up today and have bench warrants ordered. it makes you a little skeptical about confidence in people showing up, which is why you need a program that has support services where somebody says, hey, we're not just going to get you out of jail, we're going to give you a job, we're going to give you a place to live, we're going to call you, you're going to have to call us, and if you don't call us, we're going to put you back in jail. But you need a system with that, because if a person doesn't have a job, doesn't have a place to live, and has a drug habit, and you make their bail and put them out on the street, you would not bet heavily that they'll show up for trial.
Although it's interesting, right? If most people show up, the overwhelming majority of people in New York City are actually released with no bail at all, and the overwhelming majority of people show back up in court. So I'm not even sure that cash bail provides the incentive. I think most people come back to court, most people respect the authority of the court, and most people recognize that not coming back to court is going to make it actually more difficult for them to fight their cases in the long run. So I'm not sure you need sort of cash bail at all.
Although I'll tell you, one of the great, I should have brought this statistic, but one of the great sort of, makes your eyebrows raised is how many outstanding warrants there are in New York for people who didn't make their appearances. So it's true, the great majority return, but that's still a lot of people who just don't show up. And it's kind of sad too, because then they apply for their real estate license, and someone says, oh, sorry, I have to arrest you. So.
This question goes to prosecutorial discretion, which is implicated in a lot of what both of you have said. But I think there are two cases out there that do not merit prosecution. They're the most publicized cases we've got going today. Roger Clemens and Edwards. I think there's a really strong argument that there's no deep societal purpose, no deep societal victim in either of those crimes to warrant the kind of effort, expenditure, resource, dedication we got there. But I'd be interested in your views either on that case or commentary on whether you think prosecutorial discretion is exercised properly within the system of law enforcement in New York.
Roger Clemens is a Red Sox, so he has to be prosecuted. As for John Edwards, that's a really great question, and again, I can only state my own view, which is, well, I won't even state my own view. I'll say this: I was impressed with what that jury did, and I was impressed because, I guarantee, well, I hope Robin and I share this. People say, how do you feel as a trial attorney? I'll tell you that the overwhelming feel I have at the end of the trial is humility in the face of a jury. I mean, juries are great. Never get rid of the lay jury system. And you see that in John Edwards' case, where you've got a very celebrated defendant, and you've got some of the most just sort of horrible things that a human being can do in this world. And still the jury, I think, obviously, looked at the evidence and looked at the law and said, yes, but have the charges been proven beyond a reasonable doubt? And anybody in this room might come to a different conclusion, and again, you point out that even aside from the question of whether he was technically guilty, is the question of whether the resources are merited. But for me, this morning as I was reading about the case, I said, boy, oh boy, I wish I could pin a medal on those jurors. Not to say they came to the right decision. I don't know the evidence well enough, or the counts well enough, or the law. I don't do election law. But it seemed clear to me that they were, some judges, when they dismiss a jury, give them a little talk about how service on a jury is the highest calling in a democracy. And I would always pause at that and say, after all, people used to get drafted. In my day, people got drafted and went off and died. Is really sitting on a jury a higher calling than that? You know what? It is. It's the highest calling that we have. What those jurors did, I think, was truly remarkable.
I would say that I don't think prosecutorial discretion is exercised nearly enough. I think that there are enormous political pressures.
At the lawyer level of the prosecutor or at the street level of the police?
Well, certainly the street level of the police, the prosecution's supposed to check the police conduct, right? Like the only thing that stands between the police bringing a case to the prosecutor and somebody actually remaining in jail and being prosecuted is the discretion of the prosecutor at the charging moment, right? Because they make the decision to do the charging. I would tell you that if there was a serious analysis done at that point, at the point that police officers bring a case and a human being into the system, and that goes to the prosecutor, and the prosecutor is supposed to be weeding out those cases and looking through those cases and assessing them for whether or not they can be proved, whether or not the searches are legal, whether or not constitutional standards have been honored. If the prosecutors were doing a better job at that, we could eliminate a lot of unnecessary prosecutions and prosecutions that actually will devastate people. If the prosecutors in New York City were simply looking at the marijuana cases, the research shows, you would find that 40% of those cases would never go forward because 40% of them are based on completely unlawful stops. So that discretion is not happening, right? Do I think a lot of attention gets paid to whether or not to bring a case against somebody like John Edwards? Sure, I think a lot of prosecutorial discretion. I think there's a lot of conversation that goes on about that. There's far less conversations going on sort of for poor people who are coming in the system who really are making up the majority of the criminal justice system, and not a lot of discretion being exercised in the right way there.
This is a very New York specific question, but in New York, as a defense attorney, would you be willing to see a change in the laws for felony cases where, as opposed to a prosecutor having 6 days to decide whether or not to charge someone in a grand jury, you would give them longer in order to use that discretion, but would you be willing to allow your client to stay in jail longer at that point? I mean, because this is very specific. There's too much.
It's very specific, right? It's very unusual. New York's very unusual that it still is a grand jury system that functions that way.
But
a lot of places don't.
I was in Peter's office for 6 years, and that was always a major part of our jobs. You're dealing with very serious felony cases. You have 6 days to decide whether or not to indict someone.
But see, no, you have the answer right at your fingertips.
No, but you have 6 days to hold them in. But if it's a very serious case, you don't want to make the mistake of allowing someone who's committed a serious crime to go out there and commit a second serious crime or a series of serious crimes. How do you feel about that? I mean, what's your solution to that?
I feel like if you gave us back preliminary hearings, which are authorized, right, to have instead of the indictment, then you wouldn't be stuck in that position. But the prosecutors choose not to grant preliminary hearings because then the defenders get discovery into the strength of the case. Also, if you would reform the bail statutes, then maybe we'd be willing to give you more time. But if people are sitting in jail, and they're sitting in jail on serious amounts of bail, you ought to be able to do an assessment in that amount of time. And if not, do a preliminary hearing.
A little background.
And establish whether there's probable cause.
I'm very impressed with the well-informed questions we're getting. Obviously, this is a self-selected audience. Because, believe me, the average Princeton graduate could never hold this standard. But anyway, and where'd you go, Brown?
No, I went to Berkeley.
Berkeley, oh, good heavens. No wonder she's so upset about marijuana arrests. Just to give a little background to the question, in New York, we as a prosecutor have a choice. If a defendant is arrested for a felony and arraigned for a felony, and is held in either on remand or in lieu of bail, we then have essentially 6 days to do one of two things, either procure an indictment or to hold a preliminary hearing. And as a judge rightly said, preliminary hearings are rarer than hen's teeth. Why? Well, because, I mean, let's take an extreme example. In a rape case, if we can have a secret grand jury proceeding in which the rape victim goes before the grand jury, testifies, and if the grand jury finds a reasonable cause to believe that the rape was committed, can then vote an indictment. If we have a choice between that, on the one hand, or on the other hand, holding a preliminary hearing, in which case the victim has to appear in an open court in front of the alleged perpetrator and has to be cross-examined by the perpetrator's attorney. And then, even if we win the hearing, still has to come back for the grand jury presentation, and then once more perhaps for trial. Well, of course, in an instance like that, we're going to try not to do the preliminary hearing. So it's not just a question of discovery, it's a question of, now look, and so for that reason, I guess everybody's familiar with the DSK case, right? Dominique Strauss-Kahn, who was arrested, this great French diplomat who was arrested while boarding a plane to France, and then suddenly we had 6 days to decide whether or not to indict him, and ultimately had to dismiss that indictment. But look, as I said at the outset, the criminal justice system in general, and being a prosecutor in particular, is defining the borderline between two huge overriding social values. One is safety of the community, and the other is the right of the individual. Whether 6 days is the right number of days, or more or less, is really not what's critical. At some point, prosecutors have to make very tough and sometimes tragic decisions in a limited period of time, and that's really the nature of the business.
What criminal statute or procedure in New York would each of you most like to see revoked or repealed? What what strikes you as particularly
I know,
egregious?
Sixth
The
Amendment right to
Constitution.
counsel.
That's not a New York
What-
statute.
Repeat your answer, please.
Oh, it was a joke.
I know.
That's what they taught him in Princeton. Yeah.
It was a Sixth Amendment right to counsel. Okay,
I mean, I have a wish list, but
go ahead.
my wish list would be that I would void all the drug laws. I would, we've had this conversation, you and I, Chet, but I would certainly make possession of and of low-level drugs certainly legal. And I would just decriminalize it all. And I think you would solve a lot of problems in the criminal justice system, and you would take away one of the instruments that the police have to justify the kind of policing that they do when they stop 600,000 people a year. So I think that would be one of the things I would do. I would actually put teeth back in the speedy trial statute, which has been actually taken out of the speedy trial statute. So it used to be that there was a speedy trial statute that gave you, and this goes to your timing, that gave you the prosecutor a certain amount of time to be ready to try a case. That has just been obliterated over time and through case law, and actually his former boss's refusal to amend that statute and give it its teeth. So people now literally sit in for months and months and months and years sometimes. And so the speedy trial statute is virtually non-existent in New York City at the state level. And I guess the third one is discovery, which is that New York has one of the most restrictive discovery laws in the country. In some jurisdictions, the case can't go forward and case can't go to trial unless the defense has had access to witnesses and has been able to question them in a deposition. That's at its most extreme. Other jurisdictions, you are mandated to give police reports and other information to the defense counsel. In New York, you are literally not entitled to virtually anything up until the jury comes into the jury box. And so defense lawyers, and particularly defense lawyers for the poor, are literally preparing their cases in the dark. And so what we do is we rely on our own internal investigators and people going out into the community and trying to find out what happened, because we don't get police reports, we don't get names of witnesses, we're not entitled to access to the witnesses unless we find them on our own, and basically it's trial by ambush, and they know it. They haven't done anything to amend the discovery laws because it gives them a huge advantage. But that's probably the third thing I would change.
At first I was feeling sore because her first wish was to get rid of all the drug laws, which would mean I'd no longer have a job. But then I realized then she wouldn't have a job either. So we need,
I'd be all right with that. Like, for the bigger cause, I'd be all right with that.
I'll tell you, if I could change one law, I bet it's one, I wonder if it's one that you would agree with me on. I would dramatically reduce the number of peremptory challenges lawyers get at trial. And let me tell you what that means. When you're picking a jury, you engage in voir dire, which is when first the judge and then in New York the lawyers get to question the jurors about their qualifications. Our former colleague Steve Sirocco used to call this the most insincere form of human communication yet invented. And why? Because ostensibly you're asking about someone's qualifications, and for instance a defense attorney will say, tell me, Mr. Safian, you ever been in a restaurant and asked the waiter for his check and only then you realize it's not your waiter? You were confused, you made an honest mistake? Well, do you think that the witness, the sole eyewitness that Mr. Kougasian has, do you think maybe that witness could make the same kind of mistake? Now that's, ostensibly a question about the qualifications of the juror. Frankly, we both do it. We both ask questions that are in part about the qualifications of the jurors, but also are sort of introducing our case, arguing our case, asking for assurances from jurors. Now, at the end of that process, each of us get an unlimited number of challenges for cause. So, for example, if someone says, from a prosecutor's standpoint, someone says, I've had bad experiences with the police, I can't set those aside, I would never hear a police officer's testimony under any circumstances as a challenge for cause, I can get that person eliminated from the jury, and Robin similarly. After that, we get what are called peremptory challenges, which are historically challenges for which a reason need not be given. And historically, the reason for that was, the notion was that experienced trial attorneys have a sixth sense about who is, even though they say yes, no, I'm not racist, or no, I'm not biased against cops, yes, I can keep an open mind. There are some people you just get a sense that they're just not being honest. And so the law said that each side gets a certain number of peremptory challenges, can excuse someone without giving a reason. Now, why would I reduce those challenges? Well, for starters, the number of challenges are, in felony cases, ridiculous. They start in New York at 10, and for a Class A felony, murder case, each side gets 20 peremptory challenges. Now think, you're picking 12 jurors. So that means literally out of 52 otherwise qualified jurors, you whittle that down until you get 12 that neither side can find a reason to get off the panel. Now, there's a real problem with peremptory challenges, which is that in the past they were used in a racially discriminatory fashion. And yes, by prosecutors, but also frankly by defense attorneys. On those occasions when, for example, you had, there was a case we had in our office where white cops were accused of beating an African-American arrestee who died in their custody. The defense attorneys got all the black jurors off the jury. And so the law of Batson versus Kentucky, U.S. Supreme Court finally, belatedly, came through with the case of Batson versus Kentucky, which sets up a procedure which I think Robin would agree with me can make no reasonable person happy. And why? Because it's a cumbersome threefold plan where first you have to prove a statistical disparity in the way the patterns are being exercised. Then the person exercising the challenge has to give a reason. And then there has to be an argument about whether the challenge was pretextual. And look, lawyers being lawyers, it becomes a matter of gamesmanship. And I don't know that, I mean, I certainly think that the process was improved by the case of Batson versus Kentucky, because until then, lawyers actually thought they had a right to act in a racially discriminatory fashion in using their peremptory challenges. Now, at least, that rhetoric is gone. But I don't think, I don't think when you're giving people 20 challenges at each side to pick 12 jurors, that anybody can be happy with that law.
So, yeah, I don't agree, and I don't think it's that cumbersome. I don't think it's that complicated. I don't think it's that time-consuming. And even if it were all those things, because what you're talking about are those most serious felony cases where you have a lot of peremptory challenges, it seems to me that that is an investment our system should be willing to make if you are looking at sending somebody away in a cage for the rest of their life. You probably, I think we should be willing to make that investment, and if it's cumbersome or time-consuming, I think that that's a legitimate way to spend our resources. So I don't agree that I would do away with that.
You know, I think talk about cynicism, though. You know, the people sit on juries and they answer the questions, and then they get excused from jury after jury after jury. And if they are really, honestly, people who are civic-minded and want to be fair, I don't think it does anything for the criminal justice system to just say, yeah, but you know what? The prosecutor didn't think, you know, the prosecutor thought that maybe you'd be too sympathetic to the defense, or the defense attorney thought you might be too sympathetic to the prosecution. I think, you know, diverse juries, and I mean that in every sense, not just demographically diverse, but diverse in experience, diverse in opinion, under circumstances of unanimity. How many of you have read Rawls' Theory of Justice here? Okay, everybody go to the university store, buy a copy of Rawls' Theory of Justice. You know, John Rawls said, what is justice? And he ultimately said, justice is what everyone would agree to under circumstances of unanimity if they didn't know things like whether they were going to be rich or poor in life, white or black, whether they were going to be male or female. And that, I would argue, is sort of what the jury is about. It's taking people with different experiences, different life stories, different demographics, putting them together in a room and saying, you've got to reach a decision and it has to be unanimous. And that's why I think the system works so well.
I think quickly on that topic, because we're talking about voiding laws and also the role of the jury, and going to the topic that no one really understood, which was nullification.
I don't even understand it.
I guess the idea that a juror, if they don't agree with the law, could ignore whatever, they could take whatever attack they want and acquit someone who would otherwise be.
You got a good question.
I was going to ask, have either of you ever served on a jury?
Oh,
I have tried desperately.
I got picked, and then they changed the date of the trial, and they knocked me off.
But it's interesting because probably most defenders and prosecutors have probably never served on a jury. So you really don't know what goes on in a jury room, do you?
Well.
No, I'm curious.
We hear stories.
Yeah. The first thing that happens, right? They excuse the alternates, and then and then the judge says, "You can go now." And the two of us race out into the hallway because we know the quick way to the elevator. And then, you know, it's a bigger interview than you will ever get for any job you ever take in your life, including the U.S. Supreme Court. Yes, well, what'd you think? What'd you think of my necktie? What'd you think of my joke? What'd you think of? I mean, you break it down, and we really hear a lot about juries. Well, and about how they reason. And I'll say this also. Look, you mentioned that I'm a magician. Guy wrote a really well-known book about the psychology of magic and said, you want to know what's wrong with a magic trick? Show it to a layperson and ask them what's wrong with it. They'll always give you the wrong answer, but they'll know where the problem is. Now, when we talk to jurors, and if the verdict goes against me, and I say, okay, why did you decide that? They'll give some answer that simply makes no sense in logic. So we set that aside, and we say, yeah, but they've identified where the problem was. They haven't articulated it perhaps correctly, but they know where the problem was. And so that's, so you know, in a way, yes, I've never been in the jury room. My guess is, you know, like sausage being, you know, the old expression, if you like sausage, don't watch it being made. But man, I'll tell you, the sausage that comes out of the sausage factory tastes pretty good to me. So I don't have to watch the sausage factory. I look at the John Edwards verdict and I say, you can't tell me that those weren't people who were 5 or 6 days in a jury room arguing this case before they come to one verdict and hanging on the others in a way that, and you can sort of understand what their logic was, why they felt they could reach a verdict in one of those instances, which was because it was a different donor, I think. So yeah, I have great respect for juries, but I don't think they should be allowed to nullify. And I was hoping we'd have a big fight about this. You don't want to take up the side of pro nullification?
I'll take it up if you want to have a fight.
Yeah,
I'm always ready for a fight.
Good. Okay, go.